Welcome to the Violation Scoring Procedure Tier Assignments Challenge Public Meeting. Today, April 21st, 2021, 6 p.m., California Oil Transfer. Meeting materials can be found at http://bit.ly/COT-ENVIROSTOR. Welcome. My name is Elsa Lopez. I am the Public Participation Specialist for the Department of Toxic Substances Control. Language and captions. The slides in this presentation include equivalent English and Spanish text. The presentation will be made in English, followed by the presentation, which will be done in Spanish upon request. In the next slide, we will show you how you can make this request. Automated closed caption has been turned on for the meeting. You can turn them off by clicking the CC icon or move the caption box. Meeting guidelines. By participating in this meeting, you understand that this meeting is being recorded. You may be muted for background noise. During the comments, we will focus on topics related to today's presentations. We'll do our best to assure that everyone can participate. The amount of time allowed for public comments may be limited based on the number of commenters. Thank you for your patience and understanding. Tonight's meeting purpose, Violation Scoring Procedure VSP Tier Assignment Challenge. Meeting materials available at http://bit.ly/COT-ENVIROSTOR. Media questions can be sent to Ross Edmondson, Public Information Officer at the DTSC Office of Communications at ross.edmondson@dtsc.ca.gov. Department of Toxic Substances Control, DTSC mission. The mission of DTSC is to protect California's people and the environment from harmful effects of toxic substances by restoring contaminated resources, enforcing hazardous waste laws, reducing hazardous waste generation, and encouraging the manufacture of chemically safer products. Tonight's agenda. DTSC will be presenting from now until 6:30 p.m. California Oil Transfer will be presenting from 6:30 to 7, and public comments will be from 7 to 8. Phil Bloom is the Unit Chief, Permitting Division, Department of Toxic Substances Control. Paulette Penton is the Project Manager from the Permitting Division, Department of Toxic Substances Control.
Violation scoring procedures, also known as VSP, and this is an overview. There are 6 steps that go in this process. Step one is scoring violations. DTSC enforcement calculated the VSP score for each violation based on potential for harm, extent of deviation, and frequency. The VSP facility score is calculated based on the sum of scores for the Class 1 violations as defined by Title 22, from all inspections from the prior 10 years divided by the number of inspections. The second step is a provisional VSP score. A provisional VSP score is issued to the permittee. The permittee has an opportunity to dispute it with the DTSC dispute resolution official, who is an independent from the permitting and enforcement divisions. After this, we go to the third step, which is a final VSP score and tier. In this step, a final VSP score is released by the dispute resolution officer. The compliance tier assignment is determined from the final VSP score, and the permittee is notified. In this case, the permittee would be California Oil Transfer. The permittee has an opportunity to challenge an unacceptable compliance tier assignment within 60 days. Following this, we go to step 4, which is what we are currently on, a public meeting. Within 60 days of that challenge, DTSC schedules a public meeting and mails a public notice. DTSC holds a public meeting. DTSC presents the reasons for the VSP facility score and tier assignment. After this, the permittee presents its opposition to the VSP score and tier assignment. And after, the public makes the comments, which are accepted. Following this, we go to step number 5, which is the DTSC tier decision. In this step, within 60 days of the date of the public meeting, the department shall issue a written decision regarding the owner's or operator's challenge to the facility's unacceptable compliance tier assignment. And finally, we have that DTSC notifies the permittee. If DTSC upholds an unacceptable tier assignment, that will be the final 2019 facility VSP tier. And DTSC will notify the permittee of the decision to initiate the process to deny, suspend, or revoke the permit. If DTSC changes the tier assignment to conditionally acceptable, the permittee shall comply with the requirements of the California Code of Regulations, Title 22, 66271.56. The facility VSP overview. There are 3 final compliance tier assignments. An acceptable tier is assigned to a VSP score that shows less than 20. A conditionally acceptable tier is assigned to a VSP score equal to or greater than 20 and less than 40. And an unacceptable tier is assigned for a VSP score equal to or greater than 40. Conditionally acceptable. In cases of conditionally acceptable, a permittee must schedule a compliance audit. DTSC may impose other requirements to mitigate potential harm and noncompliance as well. In the case of unacceptable tiers, DTSC shall initiate the permit denial or revocation process. As well, DTSC may issue a permit with a term of 5 years or less and may impose other compliance provisions and mitigation measures. In the case of DTSC required response, DTSC shall make a notice of final tier assignment within the 60 days after the public meeting has been done. If an acceptable tier is still upheld or is upheld, the notice will notify the owner operator of DTSC decision to initiate the process to deny, suspend, or revoke the facility permit. DTSC may issue a limited term permit, as well as DTSC may grant a conditional permit to a facility within the unacceptable tier. And if DTSC changes the compliance tier to conditionally acceptable, the facility must meet the associated requirements such as audits. For today's meeting, we will be talking of the permittee or the facility or owner operator of the California Oil Transfer, also known as COT facility. It's located in 5300 Klaus Road in Modesto, California, zip code 95357, located at the former Riverbank Army Ammunition Depot, located in the outskirts of Riverbank and in agricultural region. The VSP timeline for California Oil Transfer. The inspections that contributed to the 2019 facility VSP score were from 2009 to 2018. After this, there's a preliminary 2019 VSP score issued, followed by a dispute submitted by the permittee, in this case, California Oil Transfer. The dispute was later resolved by our dispute office. After this, the 2019 tier challenge was submitted, followed by DTSC's response to the 2019 VSP score and tier challenge, and brings us to today's tier challenge public meeting. DTSC makes the decision within 60 days of today's date.
Can you do the Spanish on that one? Because
Yes.
there's someone requesting Spanish
That's
translation.
perfect.
Okay.
California All Transfer. Cronología de VSP. Las inspecciones que contribuyeron a la puntuación de instalación de VSP del 2019 incluyen del 2009 al 2018. Luego se emitió un puntaje de VSP preliminar de 2019. Al concluir eso, se presentó la contención por parte de el permitido, en este caso, la instalación de California All Transfer. Se resolvió la contención y se envió el desafío de nivel del 2019 por parte del permitido. La respuesta del DTCC, en este caso conocido como el Departamento de Control de Sustancias Tóxicas, se mandó una respuesta a la puntuación de BCPL de 2019 y al desafío de nivel, y lo cual nos lleva a hoy, 21 de abril del 2021, para una reunión pública de desafío de nivel, donde a partir de mañana y dentro de 60 días, el DTCC tomará una decisión. CLT's basis for compliance tier, summary of violations. They were class 1 and class 2, which were reclassified to class 1. Within the class 1 violation are the most severe and involve significant risk to human health or safety or the environment. Class 2 violations, which are chronic and committed by a recalcitrant violator, may be considered as class 1 violations as indicated in the California Code of Regulations, Title 22, Section 66260.10. In the case of California Oil, the class 1 violations, a summary of the class 1 violations included secondary containment issues, hazardous waste capacity, storage of hazardous waste, and the reclassified to class 1 from class 2 were waste acceptance and training procedures. La base de cumplimiento de la instalación de California Oil Transfer. El resumen de violaciones es la suma del puntaje de violaciones de clase 1. Las infracciones o violaciones de clase 1 son las más graves e implican un riesgo significativo para la salud o seguridad humana y el medio ambiente. Las infracciones de clase 2 son crónicas o cometidas por un infractor obstinado y pueden considerarse infracciones de clase 1 como se indica en el Código de Regulaciones de California, título 22, en la sección 6626010.10. El resumen de las violaciones en el caso de esta instalación, para la clase 1, fueron los problemas secundarios de contención. Luego, al igual que capacidad de residuos peligrosos, almacenamiento de desechos peligrosos y aquellos que fueron reclasificados de clase 2 a clase 1, aceptación de residuos y procedimientos de entrenamiento. California Oil Transfer, the demonstrations for challenge according to 66271.57D of the California Code of Regulations, Title 22. The permittee is able to operate in compliance. The facility has to be able to operate in compliance. Continued operation is unlikely to adversely affect human health, safety, or the environment. Financial insurance meets the requirements, and an audit report that is currently not applicable further to 2019. A permittee must demonstrate audit report requirements demonstrating ongoing pattern of compliance with all applicable requirements, implementing all actions to correct deficiencies and address findings of prior audits is currently waived because no audits have yet been conducted. Demostraciones para el desafío por parte de la instalación de COT. Siguiendo la sección, el Código de Regulaciones, título 22, sección 66271.57D. Primeramente, el propietario debe ser capaz de operar en cumplimiento. La instalación debe ser capaz de operar en cumplimiento. Es poco probable que el funcionamiento continuo afecte negativamente a la salud humana y la seguridad o el medio ambiente, al igual que la garantía financiera siguiendo requerimientos legislativos y un informe de auditoría, el cual actualmente no es aplicable. El requisito del informe de auditoría debe demostrar un patrón continuo de cumplimiento con todos los requisitos aplicables, la implementación de todas las acciones para corregir las deficiencias y abordar los hallazgos de auditorías anteriores. Actualmente no se aplica porque aún no se han realizado auditorías. We will now have the presentation by California Oil Transfer. A continuación, tendremos la presentación por parte de la instalación de California Oil Transfer.
Oh, good evening. I'm Jennifer Hartman King of Hartman King PC, representing California Oil Transfer LLC in opposition to the agency's 2019 VSP score assessment and potential tier assignment. Before delving into the substance, I'd like to just take a moment to introduce my client, California Oil, and its owner, Mr. David Alvarez, who is present today for the meeting. California Oil is the permittee under the Series C Standardized Hazardous Waste Facility Permit that DTSC issued for COT's facility located in Modesto, California. California Oil has been the owner and operator of this facility since approximately 2017, and it was in 2012 when Mr. Alvarez first acquired partial ownership interest in the entity that previously owned and operated this facility, Riverbank Oil Transfer LLC. That entity has since been dissolved. California Oil, as the agency is aware, operates a non-RCRA hazardous waste storage and transfer facility for used oil, waste antifreeze, and non-RCRA oily wastewater. These are, of course, essential hazardous waste management services in California. If California Oil were unable to operate, businesses that rely on this facility for critical hazardous waste management services would have fewer options and incur greater expense when striving to comply with applicable waste management laws. Without this facility, there would actually be a greater risk to human health, safety, and the environment because businesses would have fewer options for these services. California's capacity to manage hazardous waste generated within the state would decrease, and additional burdens would be placed on neighboring states. Also, as the agency is aware, Mr. Alvarez is a minority businessman who has endeavored in good faith to work collaboratively with DTSC throughout his career and involvement with the facility. Historically, he has promptly and cooperatively addressed every single concern that DTSC has raised over the years. And frankly, there haven't been many of those concerns. In fact, he has continually sought to understand and abide by DTSC's interpretations of the permit and legal requirements, even when the agency has made this quite difficult with its fluctuating, often inconsistent, vague, and sometimes completely unresponsive communications. Nevertheless, Mr. Alvarez remains committed to working with DTSC to ensure that the facility complies with the permit and all applicable laws. Today, I'll explain why the facility is not and never has been assigned to the unacceptable compliance tier, and why any decision resulting from this meeting today that purports to do so now would violate the regulations and constitute a prejudicial abuse of discretion. This is because, as the record reflects, 1, the facility's 2019 inspection violation score is rightfully in dispute, and we'll talk about that further today. 2, DTSC's VSP scoring methodology applied to the facility's 2019 VSP score is flawed. And 3, DTSC has already determined that COT is assigned, at worst, to the conditionally acceptable compliance tier. This occurred when DTSC issued the facility's 2020 compliance tier assignment. In doing so, in fact, DTSC rendered the purpose of today's meeting moot. Moreover, California Oil has demonstrated that the facility is in compliance with the terms of its permit and applicable laws. And finally, DTSC has no authority to revoke the facility's permit. We'll go through all these points today, but as a result of the evidence and arguments presented today, and in addition to all the arguments that we've asserted throughout this VSP process, DTSC simply must determine that the facility is, at the very worst, assigned to the conditionally acceptable compliance tier. First, here's a brief chronology of events involving the facility's 2019 provisional inspection violation score. On September 27, 2019, DTSC issued a 2019 Notice of Provisional Inspection Violation Score to COT. There, the agency asserted a total provisional inspection violation score of 132, resulting in a proposed facility VSP score of 66. On December 13, 2019, COT submitted its 2019 VSP score dispute document, outlining its primary arguments against DTSC's assessment of nearly all proposed inspection violation scores. In the dispute document, COT presented evidence and arguments supporting the position that the inspection violation score should total no more than 6, resulting in a facility VSP score of no more than 3. On September 25, 2020, over 6 months after the regulatory deadline to do so, DTSC's dispute resolution official issued the agency's decision regarding my client's 2019 VSP score dispute document. In that decision, DTSC agreed to reduce a couple of the inspection violation scores, and this resulted in reducing the agency's asserted inspection score total from 132 to 109. And according to the agency's calculation, a facility VSP score of 54.5. This slide presents a summary table noting the scores assigned to each alleged violation that is the subject of the facility's 2019 inspection violation score assessment, as well as the facility's proposed revised score for each alleged violation. The slide also provides at the bottom the total inspection violation scores and the 2019 facility VSP scores proposed by DTSC and by COT respectively. It's important to note here that the 2019 facility VSP score reflected in this table are based on DTSC's use of only 2 inspections as the divisor in calculating this score. This calculation methodology is flawed for reasons I'll address shortly and constitutes a failure by the agency, in fact, to follow its own internal guidance. It's also important to note that none of these alleged violations have been proven in any judicial or administrative proceeding. Any decision by DTSC that uses these unproven allegations against COT in the VSP process is an arbitrary and capricious abuse of discretion. Because DTSC has purported to allot us only 30 minutes to make this presentation, and there's a whole lot of information to go through, I'm not going to reiterate all of the arguments reflected in the record on this matter. California Oil, of course, expressly reserves and continues to assert all arguments regarding all violations alleged against the facility. But for this meeting, I'll specifically address 2 sets of alleged violations, which are the most egregious examples of the problems in this matter. First, I'll address the first 2 alleged violations highlighted on this slide, numbers 1 and 2 from the 2012 inspections. Then I'll address the next 4 alleged violations highlighted on this slide, numbers 3, 5, 9, and 10. From the 2016 and 2017 inspections. First, let's talk about the 2012 inspections. The first purported violation from these inspections involves alleged receipt of drums and totes of used oil and oily waste from offsite sources by the prior owners of Riverbank Oil. This was well before Mr. Alvarez acquired an ownership interest in that entity. The second alleged violation involves an allegedly inadequate training plan that was already in place when Mr. Alvarez acquired his ownership interest in the facility in 2012 and even longer before COT began operating the facility in 2017. My client's dispute document includes multiple bases for challenging these alleged violations, all of which are well-founded and should be considered by the agency at this stage. Today, however, I'll highlight just a couple of those bases in light of the present stage of these proceedings. Importantly, DTSC's inspector did not identify any Class 1 violations during the 2012 inspections, not one. Instead, both of the alleged violations were correctly classified as Class 2 violations at the time of the inspection. And they can't be considered Class 1 violations because they don't constitute a, quote, chronic violation, end quote, or one that was, quote, committed by a recalcitrant violator, end quote, as required by the regulations. In fact, neither of the violations even occurred during my client's operation of the facility. And the second was cited just months after Mr. Alvarez acquired an ownership interest in the operating entity. Moreover, both of these alleged minor violations were addressed swiftly, and neither of them involved any threat to human health, safety, or the environment. Also, critically, these alleged violations, as I mentioned before, have not been proven. They have not been adjudicated in any administrative or judicial proceeding, and neither of them have any bearing whatsoever on the current owner's ability to operate the facility in compliance with the permit and applicable legal requirements. For these reasons, in addition to all the others addressed in California Oil's dispute document, these alleged violations should be disregarded for purposes of determining the facility's tier assignment, in addition to any other DTSC determinations regarding the facility under the regulations. So turning now to the alleged violations from the 2016 and 2017 inspections. Alleged violation number 3 from the June 23, 2016 inspection report asserted that then owner-operator Riverbank Oil violated the 2001 permit terms by moving a filled rail car out of the railside secondary containment area before a hazardous waste transporter signed the manifest for the rail car. Alleged violation number 5, quoted on this slide, also pertains to the same alleged unauthorized movement of filled rail cars outside of Building 11. Likewise, alleged violation number 9 is yet another purported violation stemming from whether and when the operator may move filled rail cars outside of Building 11. And finally, alleged violation number 10 is the 4th purported violation stemming from whether and when the operator may move filled rail cars outside of Building 11. Thus, alleged violation numbers 3, 5, 9, and 10 are all based on a single related issue: alleged unauthorized movement of filled rail cars outside of Building 11 before transferring custody of the rail car to the transporter. In support of these alleged violations, DTSC cites the same 2 legal authorities. These are Health and Safety Code Section 25202A and 22 CCR 66720.30A, both of which simply require compliance with the facility's permit, nothing more. However, importantly, the permit does not specifically speak to this issue. Therefore, these are not permit violations, and even if they were, they should not be classified as separate violations because they involve a single nucleus of facts. Therefore, DTSC mistakenly assigned duplicative VSP points for what amounts to the same alleged violation of the permit, which isn't even a violation of the permit, as we'll see in a moment. This alone would be a sufficient basis to dramatically reduce the points DTSC assigned to these alleged violations. However, as I alluded to, there's more. These alleged violations resulted from DTSC's own interpretation and instruction to the facility, Riverbank Oil, only moved filled rail cars outside of its secondary containment area while they awaited transport under manifest because the operator of the facility believed DTSC had authorized it to do so. Previously, in 2012, in the August 20 and 27, 2012 inspection report, the inspector noted as an observation only and not a violation, as quoted on this slide here, that, quote, Riverbank had been cited in the past for having rail cars sit outside of secondary containment. The facility was aware of this problem, but stated that it was certain that Riverbank Oil had been granted authority to cite rail cars outside by DTSC. When this was raised by DTSC's inspector in 2012, Mr. Alvarez repeatedly sought clarification from DTSC on the precise circumstances in which the operator could move filled rail cars out of secondary containment while awaiting transportation under manifest. These requests for clarification included numerous telephone calls and messages left by Mr. Alvarez for Alfred Wong in the DTSC Berkeley office, as well as multiple written requests for in-person meetings with Joe Hunt and Alex Bailey of DTSC. Well, lo and behold, internal DTSC correspondence, a piece of which is depicted on this slide here, reveals that going back to at least 2012, the agency, in fact, did not view the movement of rail cars outside of Building 11 as a citable permitting issue or violation. But instead, the agency viewed this as a, quote, transportation issue. What is more, DTSC specifically advised the facility that, quote, it was okay, end quote, to move the rail car out of the permit area. And COT relied on that direction from the agency. In other words, the facility's movement of rail cars complied with DTSC's own interpretation and instruction. And all alleged violations purporting to require otherwise must be withdrawn and cannot be included in any VSP score calculation. Any agency decision otherwise would be a blatant and actionable abuse of discretion. All of the alleged violations we've just discussed are based on a single nucleus of facts, as I mentioned. That again is alleged unauthorized movement of filled rail cars outside of Building 11 before transferring custody to the rail car to the transporter. And DTSC's 2019 inspection violation score for the facility improperly seeks to impose 47 inspection violation points for multiple duplicative alleged violations, all of which the agency itself understood and characterized as non-permit violations since at least 2012. Listen, it's important to pay attention to what we're talking about here. These alleged violations do not involve any discharges to the environment or any other threat of harm to human health, safety, or the environment. Even if these were validly asserted permit violations, which they're not, they would amount to a simple paperwork violation. At bottom, the question here is whether rail cars can be moved just outside of Building 11 to the location where the transporter picks them up before the transporter signs the manifest. That's it. That's what we're talking about. And 47 points were assigned for that alone. There's simply no threat of harm to human health, safety, or the environment, and therefore DTSC lacks any authority to revoke the facility's permit based on these unproven alleged violations. The facility's inspection violation score should be calculated as described in my client's dispute document, but even if the agency were to disagree with all of the arguments that we've made, at the very least, it should agree that California Oil should not be penalized for the alleged violations discussed in the presentation today. It just simply shouldn't. Striking these violations from the inspection violation score would reduce the total to 41. Dividing the score of 41 by the 2 inspections factored by DTSC would yield a VSP score of 20.5, which would be in the conditionally acceptable range. However, DTSC's decision to include only 2 inspections in the denominator in this calculation is another prejudicial abuse of discretion, as I'll explain further next. DTSC's VSP calculation for the facility failed to properly account for all inspections in its calculation. Here we've listed the inspections that DTSC counted, and as you can see, the agency lumped together 2 inspections performed in 2012 and 3 inspections performed over the course of 2016 and 2017. This violates the law and internal DTSC guidance. First, DTSC's methodology violates the VSP regulations. Within the 10-year period, DTSC regulations purport to allow the agency to look back to calculate the facility's VSP score. Section 66271.54a requires the agency to divide the total inspection violation score by the number of compliance inspections during that 10-year period. Section 66271.50a1 then defines compliance inspection, in pertinent part, as an evaluation of a hazardous waste facility's compliance with any operating hazardous waste management requirements set out in statute, regulation, permit, order, stipulation, agreement, settlement document, judgment, decree, grant of authorization, issued by the department, or other document establishing requirements upon operations at the facility. Under the regulations, DTSC should have included a minimum of 3 and arguably 4 inspections in the VSP score calculation for this facility, as I'll explain further in just a few minutes. But first, let's talk about how DTSC's calculation also violates its own internal guidance. As I previously noted, on the June 23rd, 2016 inspection that DTSC conducted at the facility, this was a compliance evaluation inspection. As I'll describe further in just a moment, this is a particular type of inspection according to DTSC's official inspection policy. Approximately 2 months later, in 2016, DTSC conducted a financial records review inspection, which resulted in no violations. And financial records review is yet another type of inspection under DTSC's official inspection policy. Then, over 8 months after the initial June 23, 2016 compliance evaluation inspection, DTSC conducted a 3rd inspection at the facility. This was on February 28, 2017. DTSC's violation scoring matrix for the facility groups all 3 of these inspections together and treats them as a single inspection for purposes of VSP scoring, which is inappropriately a way of inflating the resulting score. This grouping is against DTSC's own guidance, which is memorialized in an internal memorandum that was not made available until after COT submitted its dispute document. Importantly, DTSC guidance constitutes an illegal underground regulation, violates the law, and also DTSC has inconsistently applied this guidance. On this slide, we've depicted a snapshot of the first page of DTSC's relevant internal guidance document. As you can see, DTSC's then Chief of Enforcement and Emergency Response issued a memorandum to the Violations Scoring Procedure Team on February 1, 2019. That provided guidance on the agency's VSP scoring methodology. This guidance was posted to DTSC's website in March of 2020, well after the dispute document for this facility was due and submitted. And it identifies several different types of inspections. Under DTSC's official policy, There are particular types of inspections. 4 of the relevant types are listed here. A compliance evaluation inspection is a rigorous compliance inspection that checks all aspects of the facility's hazardous waste operations for compliance. A focused compliance inspection is focused on certain aspects of the facility's hazardous waste operations for compliance with all applicable regulatory requirements. A follow-up inspection is a re-inspection specifically to verify compliance with a previously issued SOV. And a financial records review is a review of a permitted facility's financial responsibility documents and is conducted in a DTSC office. Each of these types of inspection are separate and distinct from one another under the agency's inspection policy. That inspection policy is identified here on this slide. So now returning to DTSC's VSP scoring procedure guidance dated February 1, 2019. Here we've depicted page 3 of that guidance. And on this page, the Chief of Enforcement explained in the excerpt provided on this slide that when deciding whether to group multiple inspections together for purposes of calculating an inspection violation score, quote, DTSC staff may consider a CEI and an FRR as one compliance inspection for purposes of calculating an inspection violation score where the Enforcement and Emergency Response Division requests the Financial Responsibility Unit to conduct an FRR as part of the CEI. To date, DTSC has provided no documentation demonstrating that the Enforcement Division requested the Financial Responsibility Unit to conduct a financial record review in 2016 as part of the June 23, 2016 Compliance Evaluation Inspection. Moreover, DTSC's guidance also says that when grouping multiple inspections together into one compliance inspection, the agency should consider, quote, whether the inspections were conducted simultaneously or in close proximity in time to one another. On that same page of DTSC's VSP scoring procedure guidance, the Chief of Enforcement provided an example to illustrate an occasion in which 2 inspections should be treated separately for purposes of calculating an inspection violation score. This example should have resulted in DTSC treating the June 23, 2016 and February 28, 2017 inspections of the facility as separate inspections instead of lumping them together, because these inspections are even more clearly distinct than the inspections in the Chief's example. The example in the guidance document describes a CEI conducted in January 2019 and a follow-up inspection in September 2019. In other words, these inspections were both in the same calendar year, and one of them was in follow-up to the other, but they were separated in time by approximately 8 months. And in that scenario, the guidance recommends deeming these as 2 independent inspections for calculating the inspection score. In our case, however, DTSC's violation scoring matrix classifies the June 23, 2016 inspection as a CEI and lumps this together with the February 28, 2017 inspection for purposes of calculating my client's 2019 inspection violation score. DTSC's failure to treat the 2017 inspection separately is inconsistent with the DTSC's own violation scoring procedure guidance. First, as previously shown, DTSC's guidance states that in grouping multiple inspections together, the agency should consider if the inspections were conducted simultaneously or in close proximity in time to one another. And similarly to the example described in the guidance, the facility's 2019 inspection occurred over 8 months after the 2016 CEI. But making it even more distinct, the second inspection occurred in a completely different calendar year. Secondly, although DTSC's violation scoring matrix for the facility characterizes the February 27 inspection as a, quote, follow-up inspection, end quote, to the June 2016 CEI, this is contrary to the record. On March 8, 2017, in the letter depicted on this slide, DTSC staff transmitted the February 28, 2017 inspection report to the facility. In that March 2017 letter, DTSC itself characterizes the 2017 inspection as a, quote, focused inspection, end quote, not a follow-up inspection. And recall that under DTSC's official inspection policy, a focused inspection is not a follow-up inspection. Third, at other facilities undergoing this VSP process, DTSC has counted follow-up inspections that occurred within just a few months and within the same calendar year as separate inspections in calculating those facilities' VSP scores. This treatment of facilities differently for purposes of calculating the VSP score is inequitable and a prejudicial abuse of discretion, undoubtedly. So for all of these reasons, the February 28, 2017 inspection must be counted as a separate inspection and used as an additional divisor in calculating the facility's VSP score. So to sum this up, it's a lot of information, I recognize, but DTSC cannot group the June 2016, the September of 2016, and the February 2017 inspections together for VSP scoring purposes. Under the law, the agency must count all compliance inspections within the purported 10-year period the regulations say the agency can consider. Also, it's important to note here that the legislation authorizing DTSC's VSP regulations, in fact, do not authorize DTSC to pursue permit revocation for a facility based on unproven alleged violations that are time barred by the 5-year statute of limitations for civil enforcement actions and that do not involve 3 or more final adjudications of liability or convictions within 5 years. And as I've repeatedly said, none of these rise to that level. If the agency does so here, this alone would be an immediate basis for California Oil to seek relief from the court. But even if DTSC were to disagree with all of our arguments regarding the unproven alleged violations underlying the inspection violation score, DTSC must still recognize a reduction in the facility's VSP score for 2019 as follows. Without any reduction to the inspection violation score that DTSC proposed, that number would remain at 109. However, the addition of the September 2016 inspection and the February 2017 inspection as divisors for the number of inspections increases the divisor to 4. This results in a 2019 VSP score of 27.25. This accordingly lands the facility in the conditionally acceptable compliance tier in the very worst case scenario. For ease of DTSC's reference, we have listed here on this slide the pertinent 2019 and 2020 VSP events. As noted here, DTSC issued its 2019 Notice of Provisional Inspection Violation Score to the facility on September 27, 2019. The 2019 VSP score did not result in a final 2019 tier assignment since, in accordance with Section 66271.53C, California Oil preserved its right to dispute the 2019 VSP score by timely submitting its provisional inspection violation score dispute document to DTSC on December 13, 2019. The VSP regulations required DTSC to issue its decision on the dispute document by March 12, 2020. However, DTSC did not issue that decision by the deadline, and instead it did so over 6 months after the regulatory deadline. When it eventually issued that decision on September 25, 2020, the decision still did not result in a final 2019 compliance score assignment, since California Oil had further opportunity under the VSP regulations to challenge DTSC's decision. California Oil subsequently did so by submitting its written challenge on December 23, 2020. Therefore, to date, the facility's 2019 VSP score has not resulted in a final 2019 compliance tier assignment. I don't think this is subject to dispute. But instead, DTSC's potential written decision pursuant to section 66271.57F1 would, quote, constitute the facility's final unacceptable compliance tier assignment, end quote. And this event has yet to occur. I think you, DTSC, acknowledged this in your presentation slides. However, what's even more important is that such a decision now would violate the regulations and my client's rights. This insignificant part is because on September 30, 2020, just 5 days after DTSC issued its September 25, 2020 decision regarding the facility's 2019 VSP score, DTSC issued the facility's 2020 tier assignment. Based on the facility's 2020 VSP score, DTSC assigned the facility to the conditionally acceptable compliance tier. Contrary to the 2019 VSP score and the September 25, 2020 decision, the 2020 tier assignment was final immediately upon its issuance and not subject to any administrative challenge per the regulations. This is clear under the plain language of section 66271.54E. And in fact, DTSC said exactly this in its letter to my client regarding the facility's 2020 VSP tier assignment as depicted on this slide. In other words, the facility is currently assigned to the conditionally acceptable compliance tier pursuant to DTSC's own assignment of the facility to that compliance tier in 2020. And there is no statutory or regulatory basis for assigning a facility to 2 different tiers concurrently. Doing so would be an outrageous abuse of discretion. It would be wholly illogical, legally unsupported, and frankly, irreparably prejudicial. Nevertheless, even if DTSC were to reject every single argument asserted by California Oil, including the argument that the agency itself has deemed the facility to be in the conditionally acceptable compliance tier, the agency must still make a determination that changes the facility's compliance tier assignment to conditionally acceptable pursuant to section 66271.57F2. My client has already made and continues to make the required demonstrations that California Oil and the facility can and in fact is operating in compliance with the terms of the permit and all applicable laws. In the interest of time, I know it's getting late and everybody's tired, but we'll just direct the agency to California Oil's December 23, 2020 written challenge document that outlines in detail the demonstrations purportedly required under section 66271.57D. Importantly, we also note that DTSC has not cited the facility for any Class 1 violations in over 4 years. This further indicates my client's ability to operate the facility in compliance with all applicable requirements, and that California Oil's continued operation of the facility is unlikely to adversely affect human health, safety, or the environment. Also, again, we direct the agency to its own 2020 compliance tier assignment for the facility, which is irrefutable proof that the facility's appropriate compliance tier is at worst currently conditionally acceptable, as DTSC has already itself determined. Moreover, even if DTSC were to disagree, again, with every single point we've made, the agency still could not revoke the facility's permit. As the agency should be aware, the legislation authorizing DTSC's VSP regulations do not authorize it to do so. SB 673, which is codified at Health and Safety Code section 25200.21, directs DTSC to adopt regulations, quote, for the issuance of a new or modified permit or renewal of a permit which may include criteria for the denial or suspension of a permit. We've added that emphasis, by the way, but I'll just draw your attention to it. It's limited to denial or suspension of a permit. Nowhere does it say revocation. All proceedings in the VSP regulations, including under section 66271.57 that purport to allow DTSC to pursue permit revocation proceedings based on any facility's VSP score or tier assignment, are quite simply in excess of the agency's jurisdiction and therefore strictly prohibited. So in sum, we're going to bring this in for a landing here. The facility is not and never has been assigned to the unacceptable compliance tier, and there is simply no lawful basis to assign this tier now. The facility's 2019 provisional inspection violation score is rightfully in dispute. DTSC's VSP scoring methodology applied to the facility's 2019 score is woefully flawed, as I described. DTSC already determined that COT is assigned to the conditionally acceptable compliance tier. This occurred when the agency issued the facility's final 2020 compliance tier assignment. Also, COT has demonstrated that the facility is in compliance with the terms of its permit and all applicable laws. And as I described, DTSC simply has no authority to revoke the facility's permit. Thank you so much for your time today. I appreciate it.
Thank you for your presentation, Jennifer.
So Paulette, can I take a moment just to thank Jennifer for your extensive presentation. You provided a whole lot of information that I will say it was more information than I was expecting that you were going to provide. So, but thank you for adding that. And are you making that presentation and the supporting documents available to us for consideration? Is that what you? I think I heard you say something to that effect.
I'd be happy to do that. Yes, we will submit a copy of the presentation slides, and I would appreciate a copy of the DTSC slides as well.
Okay, that would be great. Thanks. So just to introduce myself in case that wasn't clear, my name is Phil Bloom. I'm the supervisor of the DTSC permitting unit in Chatsworth. Paulette, the project manager for this project, reports to me. So thank you for your presentation. We've received a couple of comments in the Q&A section of Zoom. And one of the comments is, are we going to rebut the assertions that you made during your presentation? Well, we're not prepared to perform any kind of rebuttal here, although I will point out a few observations that I did make, because the commenters or the question was, I think, asking if we're going to rebut so that they can formulate their comments better. I will say that I note the one point that you made about the financial review. It is typical during a compliance evaluation inspection for the inspectors to request a financial review each time they conduct a compliance evaluation inspection. So I would say that is normally part of the compliance evaluation inspection. They could also be handled as a completely separate inspection as well. So that it just provides a little more information for the public to understand how DTSC normally handles those financial reviews. And then secondly, with regard to the point that you made about whether the 2020 VSP score and compliance tier would supersede or somehow replace the 2019 score. We're aware that you have this theory, but as I pointed out to you earlier, DTSC is clear that the 2019 VSP score and tier assignment is a separate matter, and that's the subject of this meeting. Certainly, as you pointed out, your new 2020 compliance VSP score and compliance tier assignment are in the conditionally acceptable tier, and that is information that is relevant to the discussion of the 2019 score and compliance tier. But I will just say that it's DTSC's position that they do not replace or supersede the 2019 scores. So with that said, Paulette, if you want to introduce the comment period for the public.
Now we will continue to and begin the comments from the public. How to submit a public comment. You can submit your comments in this chat room, or if you prefer, you can do it by mail to Paulette Penton, Project Manager, 9211 Oakdale Avenue, Chatsworth, California, 91311, by phone at 818-717-6577, or by email to paulette.penton@dtsc.ca.gov. I repeat, PAULETTE.PENTON@dtsc.ca.gov. Written comments submitted or postmarked by April 21st, 2021 will be considered to have been received at this meeting. Now we will go to the opportunity to submit comments. All comments submitting, just a reminder, all comments submitted during this meeting, emailed or postmarked by April 21st, are considered by DTSC to be received during the meeting. DTSC will consider all information presented during this meeting and issue a written decision within 60 days. Ahora tendremos la oportunidad tiene la oportunidad para enviar todos los comentarios públicos. Todos los comentarios enviados durante esta reunión, ya sea enviados por correo electrónico o por correo y sellados a más tardar el 21 de abril del 2021, son considerados por el Departamento de Control de Sustancias Tóxicas como recibidos en esta reunión. El departamento considera toda la información presentada durante la reunión y emitirá una decisión por escrito dentro de 60 días.
Well, we have a question. We have a raised hand from Brian Lundgren, so I'm going to unmute him.
Okay.
Hi, my name is Brian Lundgren. I want to thank you for allowing public comment. I'm a concerned taxpayer, user of oil, and frankly, I'm really amazed at what's occurring during this meeting this evening. What I think I've learned is that DTSC has previously determined that California Oil's compliance was conditionally acceptable, but now it appears that DTSC has taken the position that California Oil is unacceptable. Frankly, I have a concern as a taxpayer that DTSC is wasting taxpayers' dollars on, frankly, a nice Wednesday evening with this process. DTSC, in my estimation, is overregulating a Central Valley minority, small-owned business that serves an essential function and makes sure hazardous waste doesn't get dumped down our drains, damage our rivers, lakes, and other waterways. As with many other small businesses, especially in the Central Valley, California Oil has had to navigate the COVID pandemic and its significant impact on operations, as well as the market's downturn. With due respect, this process is wasteful and harmful to responsible tax-paying small business. But the small business now has incurred unnecessary legal costs and other expenses, which has impacted its bottom line. So I guess my question is, why is DTSC doing this to a small business? I know you can't answer that right now, but perhaps at some point you will be able to. In conclusion, DTSC should return to its original position of conditionally acceptable, understand and agree with California Oil's premise and position, and cease the overreach and overregulating of small California business, a business which cannot possibly survive and prosper with this unwarranted enforcement. Thank you for your courtesy.
Thank you, Brian. Do we have any other comments?
Yeah, we have Bianca Lopez is next. I'm going to allow her to speak and ask her to unmute.
Hi, thank you. Good evening. Can you hear me?
Yes.
Great, thank you. I'd like to first let the presenter from COT know that it is not acceptable in any way, shape, or form to use a jobs versus health of the community to justify any type of violation, even if it is a small business owned by minorities. I would definitely take health over job first, and so will the people who live in Riverbank and Modesto. Even though the address is cited here in Modesto, it is very close to the Riverbank community. There is a school nearby the facility, and toxic waste is a serious material, and it must be properly disposed and contained. And I think that's what this violation is about. We cannot tolerate small businesses to justify these types of violations, just simply claiming that they will save jobs. I think that DTSC needs to stand their ground for this violation. I understand now the difference between the tier 1 consideration for previous years and how it is in 2020 now described as acceptable. It is not acceptable what they did previously. But at the moment, they have rectified possibly the situation. And so I would recommend DTSC to make sure that this company understands the severity of their actions and that they be held accountable. The community in Riverbank is also a minority. It is low-income Latino community who they are most affecting. I actually have a friend who used to live by that plant, who actually had cancer. And it was caused by the businesses that are in that area. That is no longer going to be acceptable. Stop trashing our community. Please properly dispose of toxic material, contain it in the proper manner. And DTSC, you need to stay strong. I know that you have a toxic waste facility in Avenal, which you are allowing them to proceed with without a permit. That cannot be the case here in Riverbank. The community here will stand up against any oil company that wants to use the claim of jobs over health and that does not properly take care of their waste. If they can't do business the right way, then they should not be able to do business in our community. Thank you.
Bianca, thank you for your comment. This is Jennifer Hartman King on behalf of California Oil Transfer. I want to be clear that there has been no discharge. There has been no release of any chemicals, oil, toxic substances, any of that. That is not what's at issue here. This is an alleged paper violation. And so I would encourage you to read the documents that are in the record on this. And I do appreciate your concerns. I think those concerns would be warranted if those issues were at stake here, but they simply aren't.
I think it's definitely something that is at risk if you are not properly containing the material. I will definitely look at and review the material and submit an additional comment via email. Thank you.
Okay, that'd be great. Listen, this is Phil Bloom again. I'm the supervisor for the DTSC permitting unit in Chatsworth, who has the oversight responsibility for California Oil's permit. And it is correct, as Jennifer said, that the violations cited do not allege any illegal discharge or illegal disposal of hazardous waste. So that she is correct about that. I am not quite sure I agree with her assertions that they are simply paperwork violations, but nonetheless, they don't allege any illegal discharge. And I will point out also that the California Oil facility is just one building and a small parking lot on the Riverbank Army Ammunition Depot, much larger facility, which includes many other operations and installations and so on. So just in case we weren't entirely clear about that, this action, today's action is not related to the overall Army Ammunition Depot. It's just that one small business that operates at the location of the former Army ammunition depot. So hopefully that clears that up a little bit. All right.
It
Matt-
does, thank you.
Oh,
And
you-
then just to be clear, cumulative impacts do matter. So just that one company actually adds to what everybody else is doing in that same building. Thank you.
Oh, absolutely. Certainly, we recognize that cumulative impacts are certainly an issue, and we do consider them with our permit decisions. And I want to emphasize that DTSC is very clear as to the jobs versus enforcement concern that you expressed, and we don't believe that any number of jobs justify an unacceptable environmental impact. So we're very clear that we can, it's our mission, as we indicated in the beginning of the presentation, to protect public health and the environment in California. So thank you for your comment.
And again, there have been no environmental impacts here in this particular case.
So we're going to move to our next comment from Joe. I'm going to allow you to speak. Thank you for your comment, Bianca.
Good evening, am I on?
You are.
Oh, thank you very much, and good evening to everyone. I'm Joe Conyers, and one more clarification on the subject that was just being discussed. We're talking about wastewater, used oil, antifreeze. These are all material or substances only regulated by DTSC, not by EPA. Just big clarification on that. EPA has no bearing on any of this. They do not regulate any of these materials. As I said, I'm Joe Conyers, and I'm going to talk about the character of Mr. Alvarez and a little bit about the facility. I have known Mr. Alvarez for over 20 years. I first met him when I was working as a program manager for Kern County Environmental Health. As a program manager, during my tenure, worked with DTSC on many, many occasions as that program manager. Unfortunately, Mr. Alvarez came under circumstances with us at one point while operating Kern Oil Filter Recycling. At that time, KOFR was just getting off the ground, and we discovered some compliance issues. We were seriously considering legal action based on that threat to public health and the environment from mismanagement of possible hazardous waste. We explained the requirements and what he must do to come into compliance. After explaining the requirements, Mr. Alvarez responded that if given a chance, he would comply and explain the circumstances of why his operations were not as we expected. Within a few weeks, Mr. Alvarez had gone above and beyond of what we expected. That story shows me Mr. Alvarez's character, willingness to comply if treated fairly, and made fully aware of the requirements. He was unwilling to argue or be confrontational with regulatory officials. That is his character. His character is to try and comply and get along and run a small business in compliance. Jumping to the present, I have worked for Mr. Alvarez and his company to assist them with regulatory issues since my retirement in 2016. In that time, he's explained numerous times that all he wants to do is comply and operate his facility in compliance. However, it seems he cannot get a break with DTSC. He is looking for a fair and honest treatment and a fair playing field, equal playing field. I am in disbelief that we are here given the cleanliness of his facility, willingness to operate with DTSC, and expenditures he has made to operate a model facility. Versus many of my other clients, which operate with such overburdensome regulatory oversight, and can tell you that they're amazed at how they operate with impunity, given their self-assessed knowledge that they operate with certain risk of being inspected by DTSC and harshly penalized. Also, if this facility is closed for Where will operators be required to recycle the waste currently handled at COT? Bakersfield or LA? That is not a prudent answer given the environmental consequences of driving and hauling millions of gallons, hundreds of miles south to this location. The violations cited leading up to this action are primarily Class 2 violations, in my experience, and present minimal risk to health and safety in the environment. These are my comments, other than why are we even here? Other than to give Mr. Alvarez a hard time to operate this facility. Thank you for the opportunity to present my comments.
Thanks, Joe. Much appreciated for your comment.
All right, we have another comment from Josh Teves. I hope I'm saying that correctly.
Sorry, this is Josh. Can you hear me?
Yes, please go ahead.
Great. So I run a large emergency response company in Northern California, and we use the facility quite a bit. This is a big part of our business. Without it, we essentially have to drive our waste to Southern California, which obviously is more expensive. Increases risk on the freeway for my drivers and for potential spills. The other thing we notice in my business is without adequate facilities, it leads to a lot of illegal dumping. So the amount of illegal dumping we have to clean up goes through the roof, which is a real threat, right? The actual discharge of toxic materials to the environment. I've looked at the violations on COT's record. I think we made the comment earlier about them being paperwork. It may not be just paperwork, but they are administrative, right? We're not talking about actual releases of material to the environment. They're largely administrative. I think the process, which is new, right? This VSP process is new to California. I think needs some work. I mean, we're talking about 2019 scores in 2021. Sandwich between that, we have 2020 points, which puts the facility in the adequate category. A comment was made earlier that those don't supersede 2019. I don't necessarily agree with that. It's obviously DTSC's interpretation. I will say that if the process can't be resolved in a calendar year, it probably shouldn't be an annual scoring procedure. Then we're going to get pretty messy if the 2021 scores come out before the 2019 scores are resolved, for example. So I think that process needs to be cleaned up. I also think it needs to be equitable. I've looked at other facilities that hold standardized permits, and some of them, have to have 20 inspections in a year, which obviously if you got a lot of points, but you get divided by 20, the result is a lot lower, right? COT only has a handful of inspections over the last decade. And I don't think that's fair to COT, and it's probably not fair to the other facilities in California. So I think the process needs to be tweaked a little bit so that it is equitable, because it's clearly not. Just numerically, it's not a fair process. So I think, I'd like you to take those things into consideration. I'd also like everyone to consider, what the absence of this facility means to the community in the region, because that's a big blow to the region. Lady made the comment earlier about exposure to toxic materials. That happens everywhere all the time. It's the properly permitted facilities that are made to handle. And I think you look through the record and understand we are talking about administrative violations and not actual, pollution, discharge to ground. So that's important to consider. We're talking about manifest issues essentially. So with that said, I'll end. I just want to say that the facility is important to the region, and properly permitted facilities are important, because without them, people don't have a place to dump. It's cost effective, and you will see actual pollution to the environment increase. Thank you for your time.
That's everything we've got in the verbal Q&A and the the question and answer feature box so far.
Okay, well. You guys hearing me? I can't tell whether I'm muted or not.
You're not.
Okay, great, thank you. Well, so if there are any other comments, please either raise your hand or submit them in the Q&A box. But Josh, thank you for your comment. Really appreciate your thoughts on the matter. I will acknowledge the long duration that it took to get the 2019 VSP scores out. We are aware of that. I'm going to explain some of why that was. The legislature, when they wrote the law and directed us to develop regulations to implement the law, they did not provide any new staff people for us to do it. And when it came time to actually develop the scores and the tier assignments, that had to be done for nearly 100 facilities for 10 years worth of violations. And unfortunately, it did take a long time to calculate those scores and double check them and make sure that they were accurate, and then issue them, and then consider the disputes and so on. So yes, we recognize it took a long time, and some of them were delayed by many months, as was pointed out. Now, going forward, of course, there's a number of factors that are going to make for much more timely results and decisions in this process, because now going forward, we'll only be going a new single year addition of violations to the score. And so they'll be able to be calculated much more promptly. And as well, we've requested a significant number of additional positions from the legislature so that we'll be able to process them even quicker and more efficiently. So hopefully that addresses that concern that you raised about the timing. We recognize that it has taken a long time for some of the facilities, and we apologize for that, but going forward, it probably will not be that way. Do we have any more comments or questions? Okay, well, very good. Thank you so much, everybody, for joining in. I really appreciate the participation and the input from the commenters. Thank you, Paulette and Elsa and Marcia, for your support and for your efforts to put this presentation together and to make this meeting run as smoothly as it did. I really appreciate all your work. This is the first of what will probably be several meetings going forward with for the unacceptable tier challenge meetings as part of the VSP process. So I appreciate everybody's patience with us as we put together and presented this first of these meetings. Sometimes the first ones can be a little more challenging. So at any rate, I appreciate all your efforts, everybody, and thanks once again. Paulette, did you have any last minute words?
I want to remind anybody, whoever was late for our meeting, let me go back to the presentation. I apologize, whoever was late for the meeting and would like to review the materials in detail regarding the VSP scoring and all the information regarding the violations in more detail, you can find them and I will go to that slide immediately.
Okay, good.
I apologize for the. Oh, here we go. You can find that information at http is it semicolon? Sorry,
it's colon.
Colon. I apologize. My English isn't the greatest. http://bit.ly/COTENVIROSTOR en Spanish. Quiero recordarles, si usted llegó tarde y desea ver los documentos en inglés a mayor detalle, por favor vaya a la página de EnviroStore indicada A continuación, a http bit.ly/COTENBCOR.
Very good. Thank you, Paulette. And now I will point out also for anybody that may be having trouble getting that link to work, you can go to DTSC's public webpage. That's dtsc.ca.gov, and you can look for the EnviroStore section of our public webpage, and you can search on California Oil Transfer, and you will be able to find out a tremendous amount of information about California Oil Transfer, about the permit, about enforcement actions that have been taken. There's information presented there about those inspections that were the subject of the VSP, about what the violations were, and so on. So that information is available at DTSC's EnviroStore webpage. So hopefully everybody's able to find any further information that they need. And also I will remind you to submit any further comments or questions or material to support your comments to Paulette at the email that she mentioned earlier. Paulette, do you want to repeat your email address again?
Yes, I will put it on screen as well.
Okay.
There we go. The email, if you cannot find the documents, you can also send me an email and I can help you. I can send you a link to locate them easier for you. Or you can send your comments to paulette.penton@dtsc.ca.gov. I repeat, PAULETTE.penton@dtsc.ca.gov. En español, si desea mandar comentarios en español o en inglés, por favor, mándelos a mi correo electrónico, el cual es paulette.penton@dtsc.ca.gov. Repito, PAULETTE.penton@dtsc.ca.gov. Si no puede encontrar los documentos en el link, la página web indicada previamente, usted puede mandarme un mensaje y le puedo ayudar a localizar estos documentos. Muchas gracias.
Thank you, everyone. This concludes our meeting. And we appreciate all the comments, questions that were asked. And since this is the first one that we do, thank you for your patience and for everyone that has worked hard to get this through. So this time, the webinar will be finished.